All right, we're live on Herald Inside LI. Just going to give everyone a moment to join us this morning, Tuesday morning, for Herald Inside LI's Success in Family Business webinar. Thank you, everyone. Hello, hello, hello. Good morning. Welcome to Herald Inside LI. I'm your host, Sky. Over the last few months, Herald Community Newspapers and richer live events have produced nearly 30 different webinars covering a range of important, informative Long Island topics and issues such as education, real estate, the COVID vaccine coming to the island, and small businesses and PPP loans. Today, we'll turn our attention to owning and operating family businesses, which I didn't realize before we started planning this webinar that most Long Island businesses are family-owned businesses. In fact, family firms comprise 90% of all businesses in North America. In fact, also, Herald Community Newspaper Group is a family business formed in 1964, and that's a small family business compared to Walmart, the country's largest family-owned business in this country. So I'm here this morning to host and moderate a discussion surrounding this topic of family business. And I want to take a moment to thank our sponsors, Barnes & Barnes PC, a law firm, and Marshall & Stevens, a business valuation firm, both specializing in family business affairs. And we're lucky to have with us today experts from each of these offices. Leo Barnes, attorney with the law firm Barnes & Barnes in Melville, and John Agogliati from the valuation firm Marshall & Stevens. So thank you to our panelists for joining us. And I'm going to ask each of the panelists to tell us a little more about themselves to best give our audience a chance to really get to know them, because as always, you can use the Q&A feature at the bottom of the screen to type in any questions that may come to your mind as we go through today's conversation, and I'll pose them to Leo and John as the conversation continues. Some of the topics that these gentlemen are going to cover today include how to properly set up or structure a family business, potential issues that can arise and how to avoid them, best practices for maintaining transparency and ensuring the proper agreements are in place, the importance of having outside advisors when it comes to checks and balances in family business, and what they call the 5 Ds of succession planning. Right before we begin, I want to do something we always do at the family-owned business of the Long Island Herald. I'm going to ask our panelists to smile and wave as I take a screenshot of us together. Great. And this screenshot will be used in a news article that will come out in Herald Community Newspaper. It'll be in print and online and papers distributed throughout Nassau County. And it'll recap today's discussion for anyone who may have missed it. And as always, today's episode is also recorded and will be shared on our social media channels and YouTube channel, as well as on our website, herald.com/insideli. So you can't run and you can't hide from this information. So without further ado, I'd like the panelists to introduce themselves, and then we'll dive into some questions. And again, audience, our live audience, if you have questions, please feel free to type them into the Q&A function at the bottom of the screen. And let's begin with you. Leo, tell us about yourself.
Thanks, Sky. Good morning, and I'm thrilled to be here with you and with John and with all of the attendees out in cyberspace. As you noted, I'm a commercial litigator with the law firm of Barnes & Barnes in Melville. And the other Barnes in Barnes & Barnes is my brother, Matt. So like many of you, I'm also a partner in a family business. At Barnes & Barnes, we focus upon complex business litigation and related business transactions so that we can deliver solutions which align with a client's business objectives. And we represent many family businesses across the New York area.
Good morning, everybody. My name is John Agogliati. I'm a managing director at Marshall & Stevens Incorporated. I'm the national practice leader for the dispute resolution and litigation services service line, and also I lead the financial services line. So my main focus is really business valuation and privately held business valuation. So I've been doing that for over 20 years. Marshall & Stevens is a full service valuation firm. All we do is valuation, no accounting or auditing. We're just all valuation, anything from real estate to machinery and equipment up to business interests. We've been around since, I haven't been around since the 1930s, but the firm has been around since the 1930s. And again, we're just a full service valuation shop.
Okay, great. And just to reiterate, if anyone has any questions, please type them in and I'll pose them to Leo and John as we go through today's conversation. And the Herald also collected questions in advance of today's webinar, so I'll be posing those to Leo and John throughout the course of the conversation, and we have an hour together today. So let's start with the basics. Leo, if you could, tell us the first steps to ensure someone is properly setting up a family business.
Sure. So the first and arguably the most important aspect of any properly set up family business is to make sure that there is corporate protection in place so that the owners do not encounter personal liability for the company's debts or liabilities. Obviously, this is a fundamental concept, and it should be adopted by every family business. And keep in mind, don't want to have too much doom and gloom today, but the failure to maintain your corporate books and records properly with required meetings, required resolutions, and sufficient separation between corporate and personal affairs can lead to a claim that the company has destroyed the protection which presumptively exists for a corporation, thereby subjecting the owners to personal liability. The truth is many family businesses specifically encounter difficulties because they lack formalities and structure that are often the hallmark of a non-family business. And this is an understandable and common problem. Because family members are obviously related to their business partners in a family business, they tend to relax their diligence and reduce their instinct to protect themselves and their families. We do a fair amount of litigation, and we're often approached when it's too late to resolve an issue absent of litigation. And our experience is that in the vast majority of those cases, the family business simply lacks formalities that we hope to see in place before trouble surfaces. So the first piece of advice we have is to be proactive. And you've all made a great first step today by attending and gaining some education about the issues which may impact your particular family business. Many businesses initially incorporate and don't revisit the black book until trouble starts. I know that John is going to touch upon whether it's best for a given business to be structured as a domestic business corporation, an LLC, or a partnership. And that certainly is not a one-size-fits-all analysis. So one key recommendation we make to all of our business clients is to check in with us once per year. The same way you go to your doctor for an annual health checkup or your CPA to get your taxes done. Come to the office or join us by Zoom, and we can discuss whether there have been changes to your global business environment that requires a particular course of conduct. See what's planned for the future, both short-term and long-term. Like anything else, the ounce of prevention is worth a pound of cure.
So that's a little bit of the legal perspective from you, Leo, and John, from a business and valuation perspective. Leo touched on business structure. What should business owners consider when deciding what kind of business structure they should put into place?
Yeah, very good. And I always say, again, Leo's really focusing on the legal and the protection and the logistics of operating the business. From a governance standpoint, that's what your attorney's going to help you with. From our standpoint, I'd say it's a secondary issue. Deal with the protections first on the legal side, but you still need to be aware of the tax and the valuation and the economics of what structure you pick for the business. And probably the first big step is to say, do you want to be a pass-through entity like an S Corp or a C Corp, which is not a pass-through entity? And the difference is this: C Corps are taxed really almost at three levels. They're taxed at the corporate level at federal taxes, corporate level for state taxes, and then cash flow that's distributed out to its shareholders by dividends are then picked up on personal tax of the shareholder. So that's really two-level tax or three-level tax, depending on how you want to look at it. For an S Corp or LLCs or general partnerships are pass-through entities. So the income is passed through to the shareholders. It is not taxed at the corporate level, and it's only picked up at the personal shareholder level. Now that sounds great, but there's always upsides and downsides to each of those business structures. Really for C Corp versus S Corp, it's all a matter of size, how big you want to be. C Corp is, GE is a C Corp. That's your standard kind of business. It can be as big as it wants. It can have as many investors, it can have foreign entities as investors. It's really intended for large businesses or businesses expected to grow to a large size. S corps, by the S standing for small, were designed really for privately held, closely held businesses. So the one downside on taxes for S corps or any pass-through entity is that the income is passed through to the shareholder, whether or not there were cash distributions made. So for a C corp owner, you're only taxed on the dividends you actually receive. For an S corp owner, let's say I'm a 10% owner and the business generated $1 million in income, I'm going to pick up 100,000, 10% of that income. I'm going to pick up 100,000 on my personal tax return, whether or not that business actually generated or distributed cash to me. So there's times that you can actually have cash taxes and not have the cash from the business to pay for it. But there's certain ways to avoid that. We can talk about that a little later with government stocks. So that's really the first step. Do you want to be a pass-through entity or a C corp? There's also, like I said, LLCs as well. And I think Leo's going to go into some of the downsides of picking an LLC as a structure too. That's probably one of the most popular entity structures that we see. It just seems to be very flexible. There are downsides with that. And then I think that's all I'll cover for now in terms of structure.
Right. And now that we've gone over the structure, you've mentioned some of the downsides. Maybe Leo, do you want to talk about some of the problems that could arise and how business owners can avoid these issues?
Sure. So once the structure has been decided upon, it's certainly a best practice to document the fact that the business will be governed by certain rules and regulations. And this includes, from a lawyer's point of view, drafting appropriate legal documents, such as a shareholder agreement, an operating agreement, bylaws, employment agreements, which will govern the operation of the business in an objectively verifiable manner. So the biggest problems arise when these corporate governance documents either don't exist, or sometimes worse, they simply aren't updated. And one particular challenging court case comes to mind. Several years ago, we had a family business dispute where the parents purchased a large parcel of land and a franchised car dealership for one of the leading national car dealers, such as Chevy or Ford or Dodge. And mom and dad had 4 kids, 2 girls and 2 boys. So there were 2 major assets at the time of the parents' death. There was this 8-acre commercial parcel that held the car dealership, and then there was the car dealership itself. And the problem that arose was that mom and dad left the car dealership to the boys only, which was more commonly done in that generation because the boys had grown up, kind of under the hood. They worked in the car dealership and worked with dad. But on the other side of the coin, the parents left the land, the 8-acre parcel, in equal proportion to all 4 of the children. So there was this inherent conflict of interest. On the one hand, the landlord, the owner of the land, is comprised of all 4 siblings. And on the other hand, the tenant is comprised of only the 2 boys. The conflict was revealed because you had the boys wearing 2 hats in the same transaction. And they had a unique vested interest in keeping the monthly rent as low as possible because they were paying for it from the dealership funds. On the other hand, the sisters wanted to maximize the rent because it provided them with a monthly income stream. Unfortunately, one of the brothers was a particularly dominating personality, and the sisters really didn't check in on their legal and financial affairs, kind of inherently trusting their brother to do the right thing. What we learned happened was that over a period of roughly 2 decades, the brothers would effectuate lease amendments on behalf of both the landlord and the tenant, freezing the monthly rent for 5 years at a time. And this, I'll call it a scam, went on for 20 years. Mm-hmm. So that when we were retained, 4 or 5 years ago, the tenant was only paying $3,000 per month for a property that was worth more than $7 million. So we immediately engaged an expert real estate appraiser who determined that the fair market value rent at this particular property was north of $20,000 per month. So the key takeaway from this narrative is that you've got to be involved in all aspects of these transactions. In this particular instance, the dominating brother effectuated all legal and financial decisions for the landowners and for the car dealership, leaving the sisters in the dark and essentially stealing $15,000 per month by keeping the dealership rent artificially low, which lined his pocketbook because the less the dealership paid in rent, the more he would take home every month. I know that John is going to touch upon the great importance of having independent third parties examine the books and records and the legal documents for a family business. And this is really an important lesson to be achieved from today's webinar.
Yeah, and I know when we were preparing for this webinar, you talked about how sometimes examples that you see in family business divorce are sometimes more insane than even a marital divorce. So it sounds like it's very complicated and there could be way more issues than come up in a marital divorce.
Yeah, we see that a lot, Sky. And we have, we trade horror stories or cocktail party stories with our colleagues who do marital divorces, which we don't do. And I think we have the better of the stories in the scheme of things. You have this raw emotion in a business without the kids, so it's quite interesting.
So John, from a valuation perspective, when does someone come to you in terms of how this works out?
Yeah, I mean, and we're involved in a number of different ways. I mean, I've worked with Leo for years. We help on the damages side of things. So in that particular case, we actually were retained to figure out what the damage was at the end of the day in terms of all the lost rent and the value to the business. So we would come on that side of things. But in terms, and we're going to talk about this a little bit later as well, but one area is, again, a common theme you're going to hear today, getting independent parties or independent counsel, independent advisors to assist with business really creates a better set of checks and balances. Having your CPA, having an independent CPA do the taxes, not just having someone inside the business do it. Getting audited financials if you're big enough that you want to do that. Having valuation advisors create an annual valuation review of the business. All these sorts of things, it gets away from a big source of what I see with litigation, and that's asymmetric information. It's where you have, the classic scenario, kind of in this scenario that Leo just described, you have maybe 4 owners, 2 are actively involved in the business, 2 aren't. So the actively involved owners know what's going on. They see it day to day. They know what the books are doing. They know how much cash is in the bank account. The 2 passive investors don't. And that can create just some angst there that when things start to go bad, litigation can kind of it's just a viable area for litigation. So that is again getting just outside people to verify and that don't have a bias and can just be that independent set of eyes.
Right, and that's why transparency and monitoring would be so important in a family business, to have the outside counsel. Was there anything else, Leo, that you wanted to talk about regarding that transparency?
Yeah, so John just had some great advice concerning transparency and what can go wrong when you have conflicting interests between family members. And this, of course, is not limited to just family businesses, but we see this more often than not in the family business. So transparency and monitoring are of the utmost importance in every business. But we've witnessed terrible stories from clients over the years when families essentially break up, and we call this a family business divorce, when either misconduct surfaces or the trust evaporates. So one of the keys here is making sure that there are regular meetings concerning any substantive issues. So certainly any legal developments, any significant financial developments, and business developments warrant notice to all the shareholders so that no one can claim later on that he or she was not timely apprised of these developments. So when you meet with your CPA to prepare your tax return, ideally, the meeting can be attended by all shareholders, especially in today's day and age of Zoom. It's so easy. Or certainly the draft tax return should be circulated amongst all the shareholders before it's filed. This way, nobody has an argument that there's been a surprise or misconduct.
Right, so if all the paperwork is all buttoned up and these formal agreements are all in place, it makes sense that this would be an important aspect of, filing all these things in a closely held or family business. So John, are there more things that you want to address with everyone when it comes to some of these documents?
Sure, and just a couple of other points on Leo's point, but yeah, be surprised how many closely held businesses we see that do not have just, annual meetings or biannual meetings. I mean, it's just a necessity. It doesn't have to be hours upon hours, but it gets everybody on the same page in terms of what's going on with the business, expectations for the business. I mean, that's the big thing. If people aren't surprised, it just creates a much better open environment, just like you would if you were an investor in a business where you didn't know all the owners. You'd want that kind of information. So I think, to Leo's point before, you need to kind of put that hat on once in a while, take a step back and say, if these weren't my brothers and sisters or parents, what would I want in terms of procedures? And the other small thing that I always tell people or ask for when we do valuations are take minutes of the meetings. It sounds very old school. It sounds like, why would I really need that? We're all attending the meeting. We're all there. Memories get fuzzy, and it creates a very good roadmap down, if we need to down the road to figure out where you were 5 years ago to how you got here. And well, these certain decisions were made, these certain people voted for it, these certain people didn't. It's just a very simple idea that you circulate those amongst the shareholders afterwards. Everybody sees it, everybody agrees to it, and it's filed away on a permanent file. So that's a small thing that can really help out down the line, that you have a contemporaneous document that was created along the way. In terms of governing agreements, and again, this crosses over from, it's both a legal thing that you need for good operations and logistics and day-to-day control, and it's also something that we see on the valuation side that's very important. So, and you would be surprised how many companies that we run into will ask for a shareholders agreement or an operating agreement, and they don't have one. And I'm just always shocked at that, which means then governed by state law only. So it's much better to get a well-crafted agreement by good counsel that everybody sees. Like Leo was saying, everybody reviews maybe once a year, and make sure that it's sort of a live document that evolves as the business evolves. Good governing agreements will have, management provisions. How's the business being controlled day to day? Is it by majority? Is it by supermajority? Do you have major decisions? This is a common area we see, but do you have major decisions that require everybody's consent, or again, a supermajority consent? Things like taking on debt or liquidating assets and things like that. What are the voting procedures? What are the restrictions on ownership? This is kind of a big topic, especially with a family-held business, that everybody, kind of goes into the business together. We're all friendly. You want to make sure that the business has control over who can purchase or who those interests could be transferred to down the line. If someone becomes upset and wants to get out of the business and they decide to just sell it to anybody, and that's now your new partner in the business, that can create a lot of angst, right? It's now not just the 4 siblings that are involved. There's this outsider. A lot of problems. So it's a very common provision in governing agreements to say that any transfer requires the consent of the board or consent of majority or some kind of control on that nature. The other thing you'll see are what we call ROFR rights, but right of first refusal, that if someone wants to sell or transfer their interest, they can do that, but it's offered back to the other shareholders, other members first at that same price. And there's usually a whole procedure for how that takes place. Usually it's a 30-day procedure, a 60-day or 90-day, that kind of thing. One key thing we always say is not only should you have a good document, well-crafted again, it doesn't have to be a 100-page document. Probably a good governing agreement for a small business is 20, 30, 40 pages, something like that, maybe. But whatever procedures are in there, you follow them. I mean, it's funny when we'll have, and we'll read through these agreements and we make decisions as to how the business is being operated. And then the first thing the owners will say is, oh yeah, we don't even really follow that agreement anymore. And it's like, that's just not a good idea. If you're not following it, change it, amend it and have everybody agree to the amendments versus just going off the page. Then the document really isn't worth anything. So that's sort of more on the legal and logistics side, why you want to have good agreements. From the valuation end of things, if you have certain restrictions on control, which most people would have if they were a 10%, 20%, minority owner, we call it, and certain restrictions on transfer, that can allow for certain discounts for valuations that are done for tax purposes. And this typically comes into play when someone is transferring an interest to a sibling, a child, someone in the family as a tax planning strategy, or if an owner passes away and the interest needs to be valued in their state. So when you have a restriction on control, I'm a 10% owner, I can't really control the business, I'm a passive investor, that we apply discounts to the value. So if the business is worth $10 million, I'm a 10% owner, my piece is not worth $1 million or 10% of that 10 million. It's worth a discounted piece because I don't have control. And also we discount it because you don't have marketability. This isn't the same situation where I own, GE stock or Amazon stock and I can liquidate it in 3 days. Closely held business interest is very hard to sell. It takes time, and people are going to discount that off of the pro rata number. So that becomes very efficient from the tax side of things. And if those are in place before the tax situation comes up, it's a lot better situation.
So a question actually came in as you were speaking, John, about if there's any operations that a family business should change post-pandemic. Is there anything people should take into consideration during the pandemic that would change the way that they do things?
That's a tough question. Leo, I'll push that one over to you as well.
Okay. Listen, I think globally, many businesses have suffered, and frankly, other businesses have excelled during COVID. So it's kind of tough to opine in a vacuum. But certainly if one of those two things are occurring, you really had a plummet in income, or maybe you're Home Depot and everybody's improving their houses and their income is up. So certainly there may need to be amendments made to your operations. But it really comes back to what we were discussing earlier about the need to check in with your attorney, check in with your CPA about the changes in your environment. And it may very well be that we can have this meeting in an hour and decide, look, there's been some drastic changes. Maybe you need to button up your liability. Maybe you need to coordinate with your banks on your lines of credit. Or maybe it's a great opportunity for expansion. So it's really very much a case-by-case basis. And certainly COVID has been a starting point for people revisiting that analysis.
Yeah, and I would say, I definitely agree. And I would say if you have good controls in place, good procedures in place, those controls and procedures will really be able to handle downturns in the business or rapid upturns in the business. And that shows a sign of that you have good things, in place. But, yeah, it's always a good, this is hopefully once in a very long time kind of case here, but it does give you a good reason to go back and look at things.
And one thing, John made some great points earlier, and it really illustrates the need for a financial professional such as John coordinating with the attorney to make sure that both the financial and the legal objectives are met, because they really are intertwined. So if we return for a second to my car dealership issue I raised earlier, one of the key obstacles in that case that we encountered in court was that the real estate was formed and held in the form of an LLC, as opposed to a domestic business corporation. Now, there are many viable arguments in favor of holding real estate in an LLC, and those issues are really beyond the scope of today's seminar. But one key characteristic of the LLC is that it's nearly impossible to achieve a dissolution or a breakup of the entity, absent the most extreme developments and circumstances. And believe it or not, the prospect that one partner is actually stealing from the other is generally insufficient as a matter of law to achieve a breakup of an LLC, unless the asset itself is at risk. So in that car dealership case, the sisters were really handicapped to the extent that they did not possess the nuclear option, which is to break up the land LLC and have it sold. Now compare that to a domestic business corporation. Those shareholders have a per se right to dissolution as long as they own at least 20%. So again, these issues can be addressed, in a formal governing documents. And if an entity such as an LLC with no dissolution rights owns a piece of land, the operating agreement can be created or amended after the fact. So it provides a minority member with a right of dissolution, just like a domestic business corporation. But this can't be done after the dispute surfaces. It must be done ideally upon formation, but in any case, while the members are still on good terms.
What about employing family members in the business? You talked about different family members having different stake in the business, but what about as employees? What are some aspects to consider, Leo?
Yeah, this is also a thorny topic, Sky. Listen, we see that these issues often arise in the second and third generation of a family business. And it's less and less common today as we find that the next generation is oftentimes not as interested in pursuing the family business as the founders were. But the truth is, and look, this sometimes requires an adult, uncomfortable conversation, but not all family members are built for ownership with its inherent risks and obligations and financial consequences. So our experience is that, it's rare that there should be an absolute ownership right for every family member who may not have the commitment or frankly lacks the talent necessary to properly operate a family business. So the option should remain that not everyone will necessarily be an owner, and that employment in a non-ownership capacity is perfectly acceptable. But again, getting back to what we discussed earlier, there must be documentation confirming the roles, the responsibilities, the compensation, and expectations for everyone who works in the family business, whether as an owner or as an employee.
And John, I'm sure you can weigh in on that when we talk about the valuation part.
Yeah, and one thing that we'll do when we come into evaluation of a family business is look at the comp. Look at the comp of the officers. Look at the comp of the family members. Is it at market rate? We put on the hat of I'm a controlling owner that would buy this business 100% and then make hiring and firing decisions based upon that. We will go to the marketplace. There's a lot of places to find compensation data now. So my suggestion would be if comp is being set, you really can easily get that compensation data. And at least everybody knows that, hey, we're at the high end of the range for paying brother Joey or low end of the range. But if everybody's on the same page and knows that, then it creates a lot fewer issues down the line. But that's one thing that, we always do. We call it normalizing, the comp. The way it should work is that comp should be at market rate or within a range of market. And then any excess cash flow flows to the owners in terms of their ownership pieces. So a lot of times that gets distorted, but it should be avoided if possible.
Now, you both mentioned having outside counsel and outside advisors and why that would be important. Is there anything else you want to stress to anyone paying attention here as far as having these outside advisors and a periodic valuation performed on a family business?
Yeah, and I'll take that one. I mean, the one thing to think about is, your CPA or your auditor is going to create the financial books for you. Your counsel is going to help you ensure that the business is properly and governed properly and the right controls in place. Where we can help from doing a periodic valuation, an annual or biannual basis, that not only are we really telling you what the value of the business is, which is information obviously in and of itself, but we also, a good valuation will benchmark the business. So we're going to create, a 50, 60, 70 page document that goes through and really looks at what the economy is doing, how that's impacting your industry, what the industry is doing, what the outlook of the industry is doing. We're going to do a full financial ratio analysis that shows where the subject company lines up as compared to its comparables, to its peer companies, how you've historically grown as compared to your peer companies. And that can really be, so it's not really just giving you that value number at the end of the day, but it's almost like a checkup from a valuation and an economics perspective. And if you start noticing that, well, hey, our comparable industry net income percentage, our competitors are earning a 10% net income rate, we're earning 5%. Why is that? That may shed some light. There may be some legitimate reasons for that, but at least everybody knows that. or maybe we're ahead of the curve. What does the future growth look like? We've been growing at 10% per year. Why did we only grow 3% last year? Well, there's reasons for that. We had increased competitors, we had technology changes, whatever it is. But to the extent that it lessens that asymmetric information of people that are running the business every day, know what's going on, they eat and breathe the industry, they know what competitors are coming in, the passive investors may not. And a good valuation report can give you that information and kind of help to set expectations of what's coming and what's occurred.
John's observations triggered another courtroom war story. In this case, I was not on for a plaintiff or a defendant, but I was appointed by one of the commercial division judges as a receiver, an attorney who evaluates the viability of a business operation while a dispute is litigated in court. And the company in this case was a Long Island-based entity that specialized in HVAC, which is heating, ventilation, and air conditioning. And they did large-scale commercial projects. And I mean the largest projects. They performed work on the new JetBlue terminal at JFK, Yankee Stadium, and the reconstructed World Trade Center. So it was not a huge company. As best as I can recall, it was approximately 40 employees, but the revenue was huge, exceeding $100 million per year. And again, this was another family-owned business, and there were 5 siblings who had ownership interest, and each sibling had a different role in the company. The owners were doing quite well, earning in excess of $1 million per year running the company. But greed being what it is, it wasn't enough for one particular sibling. So he developed a scheme to defraud, and it was simple in operation and very effective because nobody was watching what he was doing. So for these large-scale commercial projects, the one brother would have his subcontractor friends on the job submit fake change orders, claiming that additional work was necessary to effectuate the HVAC goals on site. That brother, his role at the company would be to review and approve proposed change orders. And these were regularly in excess of 6 figures. And then the subcontractor would then submit an invoice to that same brother in accordance with a change order. But because none of this work was actually necessary, the change order money did not have ancillary overhead. So the bad brother and the corrupt subcontractor would pocket that money 80-20 in favor of the bad brother. By the time this dispute surfaced in court, the family ultimately determined that it had been defrauded of more than $20 million over a decade. And on some level, it's almost easy to lose track of $2 million a year with revenues in excess of $100 million a year. So the other siblings sued the brother in court, and the FBI got involved, and I was appointed by a judge as receiver for the business to review the business practices while the litigation proceeded. So you can imagine the family trauma, both inside and outside of the office, as 4 of the siblings came to terms with the fact that one brother had stolen so much money from his siblings. And tragically, in that case, the brother who effectuated the fraud committed suicide soon after the FBI was called in, leaving his wife and his daughter to defend a litigation that they knew nothing about. So that case had a particularly tragic ending, but it's the perfect example of how this all could have been avoided by having objective monitors review the books and the records, which would have diminished the brother's confidence to pull off such a scam. Getting back to John's issues that he raised earlier about valuation, the resolution in that case was really hampered by the fact that the company had not performed a recent valuation over the course of the prior decade when it encountered monumental growth. So the surviving brothers and sisters took the position that the deceased brother's estate was only entitled to a nominal buyout of his shares, which was premised upon a valuation that had been performed a decade earlier before this monumental growth. So that example underscores John's savvy advice to update your documents, particularly your valuations, regularly, so that an accurate and current value is applied.
Wow. And I know that we want to talk more about succession planning and how to hand a family business down. But I think what you mentioned with this conflict resolution, maybe we'll skip to talking about conflict resolution mechanisms and how to stay away from costly and drawn out litigation within family business?
Yeah, so look, the best thing a business can do to avoid a costly and drawn out litigation is to plan what happens in the event a dispute occurs. And it's very much like a prenup for a marital relationship, right? Every couple hopes that they will live happily ever after, but the reality is many don't, and savvy couples plan accordingly in advance. So many of the eventualities that could needlessly extend a litigation can be addressed in advance. What happens if a shareholder wants to leave? What can I expect in terms of a buyout? How will that buyout be funded? Will it be in cash, in stock? Will it be in terms over a period of years, an insurance policy or an annuity? You know, each business, of course, will have their own objectives and their own means and methods to achieve a transfer from one shareholder to another. But so there are as many options as there are different types of businesses. But another key for avoiding an unnecessarily complicated, costly, and extended litigation is to contract for a provision which serves to shorten the same. In New York, we are fortunate to have a specific court for business disputes called the Commercial Division. And parties there can take advantage of the Commercial Division's Rule 9 accelerated adjudication procedure, so that the rule requires that litigations are completed and ready for trial in only 9 months. 9 months may sound like a long time to, non-attorneys, but the truth is many litigations take in excess of 2 or 3 years. But if the parties have the foresight to elect the accelerated adjudication procedure contained within the Commercial Division rules, the 9-month timeframe will really be enforceable. And another key provision for making sure that the parties only bring meritorious claims is to contain a counsel fee provision so that the prevailing party in a litigation will recover their counsel fees. The standard rule in New York is that each party bears their own counsel fees, win, lose, or draw, unless there's an agreement to the contrary which permits counsel fee shifting. In this realm, parties quickly encounter the sobering reality that if their claim or position is not ultimately determined to be meritorious, they will be subject to their adversaries' counsel fees. It's really an important reality check on the parties and their attorneys to make sure that the claims which surface in court are meritorious and worthy of pursuit.
So,
Leo, just one point too. Do you want to talk about arbitration clauses and agreements? I mean, how do you feel about putting those in? And I know that's kind of shifted over the years, but what do you think about those types of clauses as well?
Yeah, look, they have their place in the right environment. I'm not a big fan of arbitration clauses because I think it's been marketed very well over the years as allegedly faster and cheaper. My experience is that it's necessarily not either of those things. And the other ramification of an arbitration is that it is almost impossible in this environment to effectuate an appeal. So if you feel the judge or the jury got it wrong, you're really locked in there. So it certainly has a place. And the upside of an arbitration is that it is largely confidential. So on a family business, which may not want to air their dirty laundry, that may be the right forum. But there, like anything else, there are risks and rewards, and it's certainly something we look at on a case-by-case basis.
Yeah, and I've also seen where there was baseball, what they used to call baseball arbitration clauses, where you had two, it was a valuation buyout, two appraisers would come in, you'd have a high number and a low number, and then someone would pick which one was more appropriate. And those were always brought in because they thought it would make people more honest, in that the appraisers wouldn't try to take aggressive positions, which we don't take anyway. But that was the thought, but it kind of backfired in a lot of ways, that it became more game theory than valuation theory is how I always said it. And I didn't particularly like those. I think those have gone away now, but I just don't think they fast track the dispute. They kind of muddy it up. So.
Now, these items that you touched on are specific and important. So for people listening, I know a few questions came in. Maybe Leo and John, you can tell everyone what types of businesses you typically work with. Is there a specific size of business for anyone listening who may want to come seek your counsel?
Sure. So look, we represent the entire gamut. It may be a solo shareholder business and some publicly traded companies. So, and there's no particular industry. It could be finance, manufacturing, real estate, healthcare, it really runs the range. So there's not any particular area that we specialize in. But the truth is, many of these businesses have common needs and common issues that we've outlined here today.
Yeah, agreed. Valuation professionals are pretty much the same. As attorneys, we're generalists. We need to be. It's hard to really focus in only one or two particular industries. People do it. I mean, you have real estate appraisers that only focus in real estate, but they do all types of real estate. So, I've over my career valued $1 million businesses and $1 billion businesses, and we do it every day. And it's the same procedures and approaches to doing a small versus a big versus a medium. Sometimes it's harder doing the smaller ones, as weird as that sounds, but no, we cover the gamut, especially around here. Anything from Long Island, your smaller family businesses, to businesses in New Jersey or Pennsylvania. So
for anyone with any questions, this video webinar today is recorded and it's going to be posted on our website and on our YouTube channel, and we will provide both Leo and John's contact details there on the YouTube channel so you can reach out to them, and you'll also be emailed a copy of this webinar for everyone who signed up. So I want to address some of the questions that came in, as well as talk about succession planning. Actually, two of the questions have to do with succession planning, talking about passing down an LLC, or how do you transfer ownership of a family business to the next generation. So as far as succession planning goes, how should a family business best handle succession planning?
Yeah, so, one of the triggers, well, 5 of the triggers for succession planning is often accompanied by one of what we call the 5 Ds, right? Death, divorce, disability, a decision to retire, or a dispute. And our advice is, don't wait, the 6th D, don't wait for one of these 5 Ds to surface. I mentioned earlier, there are as many options for succession planning as there are different types of businesses. So sometimes that will involve a transition to the next generation. Sometimes it will involve a sale to a third party. All of your objectives can be achieved. The key here is to talk about your plans and implement them as early as possible, so you don't wake up on your, quote, retirement day and figure out that you don't have a plan.
Yeah, and we had some stats that really mirror what we see in the industry now, in that 30% of all family-owned businesses make the transition from Gen 1 to Gen 2. Only 12% make it from 2 to 3, and down to 3% make it to the 4th generation. And those are really historical numbers. I think if you went back 20 years and looked at that, it would be much higher. But recent studies are showing that Gen 1 to Gen 2 transition versus being 30% is actually dropping to around 19%. So you can obviously see where that goes down to maybe not even getting to a 4th generation. So we also, what we find is that I won't say very few, but not everyone has a succession plan, and it's not something that you can easily do. Like Leo was saying, wake up and just say, hey, I want to sell. A good sale process, if that's the plan, can take 1 to 2 years to do it smoothly and properly. Getting your financials cleaned up, getting things streamlined, getting the business running and looking as pretty as you can before you sell it. But if there's going to be transfers to other generations, that's something that you need to seek an attorney to do. You also need to seek a tax attorney, because there's certain implications to triggering gift tax events, and then, God forbid, an owner passes away, estate tax. And that's what I was talking about before, of you having those governing agreements in place with allowed restrictions that any business is going to have. Those can bring in discounts on those transfers that make them much more tax efficient, we call it. It's going to reduce the possible tax burden and chew up less of your allowed gift tax exemption, for instance, or on your estate tax exemption. So they're all things that you really need to have in place versus, once the horse is out of the barn kind of thing, it sometimes can be hard or impossible to fix that, and you're kind of stuck in the situation that you're in.
I'll jump in there for one point. What John just raised is that, and I think a common theme today is having the annual meetings and planning, right? If you decided tomorrow you wanted to sell your house or sell your co-op in the city, very few people could do that without needing to maybe freshen up the paint, maybe repair a cracked tile, maybe you have an open building permit, and those things take time, right? And the same is true for selling or transitioning or developing a succession plan. It takes time to, as John said, make sure everything looks pretty, get everything in order. And the more you plan in advance, the more successful we can be to achieve your goal, whatever that may be.
Yeah, and one area too that just comes to mind, for instance, where time is on your side. If you have a buyout provision in the governing agreement that says maybe if an owner passes away, the remaining shareholders are going to buy out the estate. In other words, to keep it sort of within the family unit. Otherwise, now the estate or the executor of the estate can become sort of involved in the business. So you want to create that provision, possibly, that the company itself will buy out, and then just, if 5 owners in the business that each had 20%, now the 4 will have 25%. So all still equal proportions, but just more concentrated. So one mechanism that you can use to do that we see is, along the way, you purchase term life insurance on the owners that would kick in, provide, with the beneficiary being the company, that cash proceeds from the insurance could then help buy out the estate of the owner. So that's another reason why, getting a periodic evaluation would help you set, making sure you have the right insurance level for that. But it's a cheaper way to fund those buyouts along the way, and everybody's kind of, it's an expense off the business, so everybody's kind of equally funding that. Versus if you don't have that in place, an owner passes away, well, now everybody's got to own up the cash to purchase, or again, potentially risk that being sold to another party.
So a question that came in about having outside consultation being so important, how does a business handle or feel about an outside firm or someone coming in to help with this checkup?
Well, that's a great question, Sky, and we see that a lot. Many are reluctant. That's the truth. And are they reluctant because of the unknown, or are they reluctant because they know there's some shenanigans going on? That's really, the heart of the question. And there's no reason to be reluctant to come in and get some advice, unless you're involved in stuff you shouldn't be involved in. So I would suggest that for those of you out there with multiple partners, if you're getting resistance on getting an objective point of view on your financials or your business plan, I don't want to sound an alarm, but you may have something to be concerned about, right? So again, it's a general question. I can't imagine an argument in favor of not having an objective company, attorney, financial person come in and take a look at the books and records. It inures to everyone's benefit who's a shareholder. And the people who resist that may be resisting for a reason. Your radar has to go off there.
Yeah, if there's nothing to hide, there's nothing to hide, right? So it's, but we see this all the time, especially if it's a pure family business, if it's been in the business, if it's been in the family for 10, 15, 20 years, whatever it is, people, why do we need others involved? But it really, it creates good control. It creates good checks and balances. You need that in a business. It solves a lot more problems than it creates. And like I was saying with his story before with the HVAC company, having good controls in place would have stopped that in its tracks. So, and that's what outside advisors will offer for you.
So we have just a few minutes left, so I want to encourage the audience, any last minute questions, please type them in. And if we don't get to your question, then we will be providing, the Herald will be providing both Leo and John's contact information to ask any questions you may have of them after this webinar. One of the questions that did come in is, what if I find out that my family business partner opened a competing business without telling me? Would I have a claim, and what would that look like?
Yeah, so that is one of the fundamental claims in the areas that we do. And that would be what we call a breach of fiduciary duty. It's improper competition, because generally a shareholder owes the highest level of fidelity to the company he's a shareholder of. And if he or she is competing on the outside, That is bad news. And we see that a lot. So yeah, there's a claim there for sure. And it's a significant claim in many cases. So that is one of the big no-nos.
Another question is it a good idea to pay personal living expenses through my family business?
No, absolutely not. That is going to provide the IRS with reason to come after you. All right, so you can have tax problems. And the other problem is, getting back to one of the first things we discussed, that is going to provide a lawyer coming after you, maybe me, maybe someone else, with an argument that you have destroyed the corporate protection that you'd be entitled to, and it's called piercing the corporate veil. So if I'm going after an adversary in court, and I find that the company has paid their personal expenses out of the business, I'm going to sue that shareholder individually and claim that they do not get the benefit of corporate protection, and I'm going to seek to pierce the corporate veil. That is a big no-no.
Does it matter if it's an LLC? Can you put more expenses in a business?
No. And listen, I don't want to provide too much specificity here, but generally it's improper to pay your personal expenses out of a corporate checking account, whether it's a partnership or an LLC or a domestic corp. Now, there'll be some argument as to whether it's really a personal expense or it's a business related expense, and I'll leave that to John and his colleagues. But as you know, you don't want to pay your personal mortgage out of your business checking account, that's for sure.
Yeah, and that's really why you need a good tax accountant that prepares the bills and keeps everybody out of trouble. And we do see this quite a bit. And I will say, sometimes it's by intent, sometimes it's by people just don't know. But that's again why you need an outside accountant. But effectively, you'd be writing off expenses and reducing your tax burden for expenses that normally you can't write off. So it can rise to the level of tax fraud if you're not too careful. So it's a common topic.
Okay, another question here. We have a mom and pop shop, which we operate as a married couple. How does that differ from a larger family business?
Well, it may not differ at all. Like John said earlier, it may be GE or it may be a solo shop. In this case, size does not necessarily matter in terms of the needs you may have and the protections you need to have in place. So the fact that it's mom and pop is fine. What I would suggest is, making sure that you've run through this checklist today. Sometimes mom and pops don't incorporate, and that's a risky endeavor because they are then subject to personal liability without that corporate protection. But, in this case, the fact that it's a smaller group does not bear one way or the other.
So as a final question now, as we wrap up, I want to ask each of you maybe to reflect, because it was a question that came in. What are the two most important things you want everyone to know about success in a family business? And you can give out your final thoughts here, any takeaway thoughts, and these two most important things as we wrap up. And let's begin with you, John.
Okay, just two. I'd say the first one is to take a step back now and then, at least once a year, if not twice a year. Put on that hat of I don't know these other four owners, or we're not friends. We're just all random people involved in this business. How would I look at this? Would I want an external auditor? Would I want external advice? How would I treat it without sort of the bias of these are my friends, my siblings, my family? Just a good lens to look through now and then. And then again, sort of that theme we've kept saying all along. Don't be afraid to have people kind of help you and create those controls and balances to stop that asymmetric information issue that can quickly lead to disputes down the line.
And Leo?
Yeah, I think, look, we hit so many points today, but I think the attendance here is a manifestation of the fact that you want to do the right thing and you're curious about doing the right thing, right? So take the next step, have that meeting, review your documents, make sure that your house is in order. If there's nothing else that COVID has taught us, tomorrow is not guaranteed. So make sure it's in order for yourself, for your family members, for the next generation, and then develop a plan and implement it.
So Thank you both so much. Thank you to our sponsors, Barnes and Barnes and Marshall and Stevens, and to Leo Barnes and John Agogliati here for joining us as experts in this family business arena. So please, I'm going to put up this closing slide here, and you can please email us at the Herald with any questions, and we're more than happy to connect you with these two experts here who joined us today. So thank you so much to the audience. Thank you to our panelists. And until next time, from Herald Inside LI.
Thanks, Sky.
Thank you, Scott.
Thank you. Thank you, everyone.
Have a great day.